Hello, I'm Jennifer Walker Gates with Walker Gates Vela Immigration Attorneys in Austin, Texas. And I am here today with our associate, Naveen Flores Dixit. Hi, Naveen.
Hi.
Naveen is an immigration attorney in our San Antonio office. And we're here today to talk about the case involving President Biden's 100-day pause on deportations, and specifically the court's ruling enjoining that policy that came down yesterday. Naveen, can you tell us, first of all, what is the case called?
The case is called State of Texas versus David Pekoski.
Okay, and David Pekoski is the current acting secretary of Department of Homeland Security, correct?
Right.
And so the reason this is important for so many people is because, a lot of people have final orders of removal in the United States. A lot of people are also facing, receiving decisions, ordering them removed out of an immigration court case or something like that. And for immigrants and families of immigrants, the possibility that you could potentially delay or avoid an order, having an order of deportation enacted against you is hugely important. This is, one of those things where, deportation is so devastating for a family that psychologists have identified it as being as traumatic for, many people as like a death. And so, the Trump administration really bore down hard on deporting as many people as possible. And what we do know, however, is that there are certain times when you can receive an order of deportation and nevertheless not actually be deported, at least not immediately. So, Naveen, first, can you tell us a little bit about what happened in this case, what led to this policy, and then what led to the court's decision? Can you give us a little bit of the background about what's happening there?
Yeah. Basically, Biden came down with this policy that said that for the next 100 days, if you have a removal order, it won't be executed, subject to certain exceptions, like for people who are in a national security risk or have committed certain serious crimes.
Mm-hmm.
And so the state of Texas sued the Biden administration, arguing that they essentially couldn't stop enforcing federal law, and that having immigrants here who have a removal order harms Texas. And so, unfortunately, the judge decided to agree with Texas, and now there is a temporary restraining order, which just means that the 100-day policy can't go into effect until the courts decide the issue on the merits.
I see. But in order for the judge to grant this temporary injunction, restraining order, my understanding is that the judge must have indicated that he believes that the case will succeed on the merits, that the case does have actual merit. Is that what
Yes.
your reading of the decision?
Yes, that is his opinion, that the case will succeed and that Texas will be irreparably harmed if the Biden policies goes forward.
And what is the argument that the state of Texas is making? How are they saying they're going to be harmed?
I'm not sure. I'm sorry, I didn't.
That's okay. What I was reading in the decision is that the state of Texas was arguing that they will be harmed because they'll be required to provide emergency medical care and potentially schooling to individuals who have final orders of removal. So the state of Texas argues this, the judge accepts it and takes nothing into account with respect to how any undocumented individual with a removal order or otherwise may be contributing to the tax base and also not receiving many other benefits that they, that most of us take for granted. So very one-sided analysis of that issue, and it's not surprising, but this is a tactic that the state of Texas has used before in front of similar judges with respect to DACA. That was also one of their arguments against the DACA program, was that the state of Texas would suffer harm because they had to issue driver's licenses to people who have DACA, which I really don't understand that rationale. But I guess, when you have a sympathetic judge, sometimes arguments get accepted that are not maybe as complete as we might like. And in any case, Naveen, what should people do when they have, like a final order of removal now? And now that this policy isn't going into effect, what would you recommend to your clients who are in that situation?
Well, definitely you want to consult with an attorney if you do have a final removal order. And sometimes the attorney can help request a stay with ICE if there's some reason that you think that the removal order shouldn't be executed. If you have a personal reason, like a family member is sick, or you're taking care of them, or you have a minor, or if you've been here a long time, an attorney can work with you to gather evidence to show positive equities as to why you should be allowed to stay and why ICE shouldn't execute the removal order. And you can also request deferred action based on humanitarian basis as well.
Yes, so those are two different remedies: a stay of removal and a deferred action. And in my experience, both of those for individuals with removal orders are filed on Form I-246. I have had luck in some cases getting ICE to agree that a person should not be removed immediately if there are significant humanitarian concerns in operation in the case. And so if a person does have the factors that you just mentioned, I would always really encourage them, if possible, to seek that as an opportunity, as an option right now, especially. Under the prior administration, ICE was not amenable in many cases to entertaining those kinds of requests. But we have new leadership. They're making a lot of effort to immediately reinstate a more favorable policies for immigrants in this country, and to recognize the important role that they play in our communities and in our families. And for that reason, I think that it is worthwhile now to spend the effort, the energy, and the make the expense, the investment to have that kind of request filed if you have a final order. So, what is next in this case, Naveen? Do you know?
I don't know if an appeal has been filed, but I'm assuming that whoever filed the suit is going to, or whoever lost is going to appeal to the Fifth Circuit. It's up in the air how the Fifth Circuit is going to rule. There's a reason why they filed this case in South Texas. And then it'll go up to the Supreme Court if the Biden administration really wants to implement this policy.
Yeah, and I wanted to point out as well that there's nothing in the court's decision that means that the Biden administration must carry out removals in any particular time frame.
Right.
And so I think in practical terms, if the Department of Homeland Security decides that they are not particularly in a hurry to remove someone, then it doesn't really matter. This decision really has no bearing on that fact. It's not like there isn't some separate provision in the law that it does say. Now, the law does say that someone with a final removal order is supposed to be removed within 90 days, unless they have a stay or unless they have some other reason why they haven't been removed. There can be all kinds of reasons why that 90-day deadline is not enforceable. There can be all kinds of factors that ICE considers: additional paperwork, waiting on flights, waiting on passports, you know what I mean? There they can reset them for, meetings and check-in and, things like that. So although the law does say within 90 days, it's not, there are significant exceptions to that under the law. So I think that the court basically just invalidated this new idea that they were just like not going in as a broad stroke, not going to remove people for 100 days, but individuals can still request, a reprieve.
Yes.
And so it's an important thing for people to know. And I thank you so much, Naveen, for meeting with me to discuss it and to share with our people about what this means for them in their cases. And I really appreciate it so much. And I will look forward to sharing more with you and learning more about how the case develops as time goes on.
Yes, hopefully we get some better decisions from some higher courts.
Yes, I hope so. And some good legislation as well.
Yes.
Starting to really push for that. And it's like, I feel like the last few days of these policy changes has been good medicine after 4 years of bad news. So
Very true. Very
yeah.
true.
All right, Naveen, thank you so much. Have a great afternoon, and we'll talk to you soon.
All right, thank you.
Audience, if you need help with your case, if you need help requesting a reprieve from removal, if you need help requesting a stay of removal, we do have experience with that, and we would be happy to work with you on it. So please reach out to us at walkergatesvella.com. You can go there to call us or to schedule an appointment, and we would be happy to help you. So thanks, everyone. Thanks, Naveen, and we'll talk soon.
Thank you.